Namaste everyone. So, from today, I'm going to read a book written by J Sai Deepak. This book, India That Is Bharat, this is a part of a trilogy series. So, two books have been released. That is India That Is Bharat, and another book is this one, India, Bharat and Pakistan: The Constitution and Journey of a Sandwich Civilization. So, I will try to cover both of these books while reading. So, let us start first this book, that is India That Is Bharat, which is the first part of the trilogy series, and it has become the number one bestseller book also in India recently. So this title is India That Is Bharat: Coloniality, Civilization and Constitution, written by a famous Supreme Court advocate J Sai Deepak. So let us see what myth he is going to break through this book. So this book contains many pages. First few pages are dedicated to acknowledgement and many commentaries that has been given by certain scholars regarding the book. So but we will start with reading the introduction page. So let us see the introduction page first, and there is a shloks written in the Sanskrit, which is I would read the translation of that is shlok from the Rig Ved, that truth is the base that bears the earth, by Surya and the heavens sustained, by law the Adityas stand secure, and Som holds his place in heaven. So this was the shlok from the Rig Ved, 10th mandal 10.85. So let us start reading the introduction page. So let us see what he's going to say about the coloniality in the this book. So introduction is, if you grew up in the 90s in a middle class Hindu family in southern Bharat. So I was born in the late 90s, so I didn't grow up in 90s, although I am the part of middle class Hindu family, but not in the southern Bharat, but in the northern Bharat. So I did not match two of three of his criteria. So not to perpetuate stereotypes, but chance. And one more important thing, that there will be certain keywords and difficult words that we will also underline, so that our vocabulary also get improved. So let us read this article, or the book. If you grew up in 90s in the middle class Hindu family in southern Bharat, not to perpetuate stereotypes, but chances are that a career in engineering or medicine featured right at the top of your life goals. My goals were no different. It is not only the southern Bharat, but in the northern Bharat also. This is the thing: engineering or medicine or IS. So my goals were no different, not just because of my limited means and exposure, but also because I was keen on pursuing a career in aerospace engineering. However, eventually I had to settle for mechanical engineering and committed myself to performing well so that I could pursue a master's in aerospace engineering. By the time I reached the end of the sixth semester in the mid 2005, I was well placed to start a career in the core manufacturing sector. In the event, I failed to secure admission to a good aerospace program. Just when it seemed like I had it all figured out, I started having second thoughts about what I truly wanted to do in the long run. This introspection was partly triggered by my visits to Ramakrishna Mutt, the writings of Swami Vivekanand, Dr. Arun Shori's incisive and pursuing books, and the spike post the election of May 2004 in the normalized and open hostility directed at the specific Indic sub identities, especially on academic campuses. Had it not been for the writings of Swami Vivekanand and Dr. Shuri, I would have missed the forest for the trees, since I was evident that the hostility, while on the face of it was directed at specific Indic sub identities in the name of societal reparation, it was in reality meant to weaken the larger Indic civilizational edifice. Systematic isolation, ostracization. So this is this meaning of this word I don't know. So I would mark that word: ostracization and acculturation. So this is also I don't know, of one Indic strand at the time seemed to be at play. It became clearer with each passing day that this hostility had the previously tacit but increasingly over support of extra civilizational, specifically colonial and non Indic systems. that stood to benefit from this motivated in inter internecine tussle. Thanks to my interaction with better informed people who were civilizationally rooted and had worked on the ground, I gradually came to understand that while the instinctive human reaction would be to protect sub identities one was closest to, the priority should be to preserve the civilizational tapestry and its foundation, while enable the birth, growth, and expression of diverse sub identities. This also meant that the protection of Indic civilizational integrity did not require the submergence of its sub identities at the altar of well intentioned, albeit misplaced, Grant Unity project. On the contrary, history seemed to teach us that the survival of the Indic civilization as a civilization depend on the flourishing of its sub-identities, with each of the sub-identities realizing that they were part of a federal symbiotic whole and that it was in their own existential interest to remain part of the whole. I also learned that the tumultuous and fissiparous state of affairs that met the eye was the product of sustained long-term investment by at a very fundamental level much before 1947. Therefore, it required at the very least, an equally sustained long term investment by the society at the most fundamental levels, namely the group and the individual, in order to undo the damage sustained by this living civilization. This realization had a profound effect on me. However, it was not remotely sure of the path I had to take. Any drastic change in paths required me to take the immediate family into confidence and convince them of my decision, and rightly so, because I had not given them the slightest inkling that I was going through a churn. But before breaking it to them, I wanted to be sure of the path myself, and so I spent the seventh semester evaluating a career in civil services and alternatively the law. In early 2006, in my final semester, I had the opportunity to present a technical paper at the Indian Institute of Technology, Kharagpur. That is when I learned that the institution was all set to inaugurate later that year a unique 3-year LLB program with an inbuilt specialization in intellectual property rights under the auspices of its newly established law school, the Rajiv Gandhi School of Intellectual Property Law. What made the 3-year law program unique apart from its marked tilt towards intellectual property law was the fact that it was open exclusively to the scientific and technological pool of the country. I realized that my future lay in the field of law, which I believed would equip me with the skills I needed to act on my convictions. In July 2006, a month after my undergraduation, I joined the program after clearing the admission process for the IIT Law School. Although I had no known relatives who were part of the legal fraternity, and I did not know about much about the profession and its inner workings. The only thing I was sure was my interest in litigation. Despite the specialized nature of the program and my aptitude for intellectual property law, upon my graduation in upon my graduation in July 2009, I was recommended by the advisor to the law school to pursue a career in constitutional law. In fact, he was kind enough to write a letter recommending me to a senior advocate in the Supreme Court who had then just been appointed as one of the top law officers of the country. Though I loved constitutional law, my personal commitments required me to take up the commercial litigation. So I started off as a civil commercial litigator in a national capital region based law firm that specialized in intellectual property litigation and allied areas and practiced primarily before the High Court of Delhi. For the first 7 years of my career as a litigator until mid 2016, while intellectual property law and competition law were my uh, I was given the opportunity to work on a few landmark matters that involved significant questions of constitutional import. In 2010, I was second chair for Greenpeace India in Tata Sons Limited versus Greenpeace International and ANR. Tata Sons had sued Greenpeace International and Greenpeace India in the High Court of Delhi for alleged trademark infringement and defamation, citing Greenpeace India's use of the Tata logo in the Pac Man style game Turtle vs. Tata. The High Court judgment In this case, while dismissing Tata's prayer for an interim injunction on the game, let down the law on the interplay between trademark law, a law for of defamation, and a right to parody and a fair comment as part of the fundamental freedoms of speech and expression under the Constitution. This judgment remains one of the finest in its genre to date and is appreciated for its nuance and clarity. A few years later, in 2014-15, I had the opportunity to second chair for the Internet and Mobile Association of India in its writ petition before the Supreme Court challenging certain provisions of the Information Technology Act 2000. These provisions required online intermediaries such as Facebook and Google to take upon themselves the task of deciding the legality of content posted by its users upon receipt of legal notices from third parties seeking removal of such content. The IAMIAI writ petition was decided in its favor as part of a batch of writ petition in the landmark judgment of Shreya Singhal versus Union of India. So I think this was the case in which, yeah, which is otherwise popular for striking down the draconian erstwhile Section 66A of the IT Act. In 2014, this case was. In the judgment, the Supreme Court recognized the chilling effect of overbroad restrictions on free speech. This judgment too remains a landmark one for its contribution to free speech jurisprudence, especially in the context of online platforms. While these cases certainly presented me with fantastic opportunities to apply my understanding of constitutional law to IPR and technology related context and vice versa, my brush with constitutional law from a civilizational perspective first and truly began after I set up an independent practice exclusively as an arguing counsel in June 2016. Fortunately, since I had earned my stripes as a litigator by then, my peers in the legal fraternity supported my decision, which kept me in good stead as an arguing counsel in civil commercial matters as well as in writ petitions before the Delhi High Court and the Supreme Court. It was around then that senior advocate Sri C.S. Vaidyanathan, one of the leading lights of the Supreme Court, recommended me to the team that to date steers the writ petition moved before the apex court by the late Swami Dayanand Saraswati. The HRCE petition, which is yet to be decided by the Supreme Court, challenges the constitutionality of the key provisions of the Tamil Nadu Hindu Religious and Charitable Endowments Act 1959, the Andhra Pradesh Charitable and the Hindu Religious Institution and Endowment Act 1987, and the Pondicherry Hindu Religious Institutions Act 1972 for violating Articles 14, 15 Clause 1, 19 Clause 1, Subclause Z, 21, 25, 26, and 29 of the Constitution. The more I read the HRCE petition and the material assiduously put together by the team in support of the petition, the more it convinced me that there was a clear causal link between the state control of Hindu temples and the visible degradation of the temple ecosystem. Also, I came to the jarring realization that a legal framework as invasive as the HRCE Acts was reserved for Hindu religious institutions alone. I learned for similar Hindu specific legislation that were in force in Karnataka, Kerala, Odisha, and several other states. Given the significant question of constitutional law involved in the HRCE petition, such as the nature and the role of the Indian state, its relationship with religion, and its treatment of religious institutions of different faiths, I was keen on contributing to the matter. I joined the team as an arguing counsel on a pro bono basis. So, bono, this is pro bono means pro bono is a kind of legal practice in which any lawyer uh, wants to provide his expertise or do practice for free of cost. So this is known as pro bono. So which gave me the which gave me the opportunity to work alongside eminent senior counsels such as Sri C.S. Vaidyanathan and Sri R. Venkataramani, who had been spearheading the matter from the beginning. Since I felt strongly about the issue, and there were several myths in the public domain as to who controlled temples and how, I delivered a few lectures on the subject within the broader canvas of civilization and the constitution. Coincidentally, it was around this period that I was approached by the trustees of People of Dharma, an NGO led by women to represent them as interveners before the Supreme Court in the writ petition moved by the uh, Indian Young Lawyers Association in relation to the Sabrimala Sri Ayyappa temple. The writ petition sought the entry of women of a reproductive age group into the temple, as well as the removal of restriction on entry of women into places of worship, prayer of other faiths as well. People for Dharma had previously launched a phenomenally successful international campaign called Ready to Wait on behalf of women to support the rights of the temple to protect its religious practices. I took up the case on the behalf of people of Dharma on pro bono basis, since it presented me with an opportunity to showcase before the highest court of the land the sheer diversity of religious practices, the unique character of religious institutions within the dharmic fold, and the position enjoyed by the deities enshrined within. I also wished to highlight the rights of deities and the devout under the constitution, and the serious complications arising as a result of the application of non-Indic ontology, epistemology, theology, and jurisprudence to the Indic ways of life, faiths, practice, and institutions. I presented these provisions on behalf of people for Dharma before a three-judge bench of the Supreme Court, which heard several others in the case. In October 2017, the bench referred the matter to a constitution bench, a bench typically consisting of five judges. By early 2017, in light of my involvement in the HRCE petition and the Sabrimala temple case, the manifest incongruity of having to establish the legitimacy, authenticity, and civilizational centrality of Indic dharmic religious institutions before an ostensibly Indian court gave me the push I needed to understand the journey of the Indic civilization better. Despite a demanding professional schedule, I started reading the works of Pandurang Vaman Kane, Jadunath Sarkar, Radha Kumud Mukherjee, R.C. Majumdar, K.A. Neelkant Shastri, K.S. Ramaswamy Shastri, S.L. Bhairappa, R. Nagaswamy, Ram Swarup, Sitaram Goyal, Dharmapal, Kapil Kapoor, Conrad Elst, Michael Danino, Shrikant G. Talageri, Minakshi Jain, and Sandeep Balakrishnan, apart from the publications of the Ramakrishna Mission Institute of Culture and Bharatiya Vidya Bhavan. This was, of course, in the addition to the writings of Swami Vivekanand, Sri Aurobindo, and other civilizational icons. My reading was based on the recommendations of better informed individuals who worked full time on civilizational issues as trained scholars, historians, civil society advocates, educators, and public intellectuals. Also, the diversity of my reading was handicapped by the unfortunate reality that I was more comfortable consuming content in English than in Indian languages, which presented the very problem I hope to understand better. On the constitutional front, I revisit the history starting from the Home Rule scheme in 1889 until the adoption of the constitution in an effort to better understand whether this document captured the essence of and reflected Bharat's civilizational spirit. B. Shiva Rao, six-volume publication, The Framing of India's Constitution, a study, V.P. Menon's The Story of Integration of the Indian States, and Justice Ram Joy's Legal and Constitutional History of India, Ancient Judicial and Constitutional Systems, served as some of my principal references in this regard. I also read through commentaries on Bharat's journey towards constitutionalism, written between 1933 and the late 1940s, which shed light on the history and prevalent thought processes on the subject. This exposure enabled me to apply the lessons drawn from the literature to live constitutional matters that had a bearing on the Indic civilizational worldview. Among them, perhaps the most significant was the Sabrimala Sri Ayyappa temple case, which was taken up for hearing in July 2018 by a constitutional bench of the Supreme Court headed by the then Chief Justice of India, Sri Deepak Mishra. Unfortunately, alongside several stalwarts of the profession, such as senior advocate Sri K. Par- Parasaran, I was granted the opportunity by the bench to present detailed arguments on behalf of people for Dharma and a Delhi based women's organization, Chetna, both of which supported the religious practices of temple and its rights. This included its right to restrict the entry of women of the reproductive age group. Unfortunately, the Constitution bench ruled in favor of the writ petitioner by a majority of 4-1 on 28 September 2018, against which several review petitions were moved. The review petitions were heard in early 2019, and later that year, acknowledging that the review petition had merit, seven question of laws were framed by the Constitutional Bench, headed by the then Chief Justice Sri Ranjan Gogoi, and referred to a larger nine-judge bench. Pending the outcome in the proceedings before the nine-judge bench, known as reference, when a larger bench is called upon to decide on question of constitutional import. The next Chief Justice, Sri Sharad Arvind Bobde, declined to grant security to any women of the reproductive age who sought entry against the temple's religious practices and beliefs, thereby restoring the status as it existed to prior to the first verdict. Alongside this, in the first half of 2019, in relation to the Sri Padmanabh Swami temple in Kerala, I had the privilege of representing the chief tantri of the temple, the chief priest of the Chillur Balaji temple in Hyderabad, and people for Dharma before the Supreme Court in an appeal from the 2011 judgment of the Kerala High Court. In its judgment, the High Court had held that the Travancore royal family had no authority over the administration of Padmanabh Swami temple after the abolition of royal titles and privileges of the constitution in the 26th Amendment Act of 1971. Okay, 26th Amendment. This was abolition of royal title. It was happened in 26th Amendment in 1971. The High Court had also transferred control over the temple to a trust which was to be managed by the appointees of the state government of Kerala. Fortunately, the Supreme Court reversed the verdict of the High Court on 13 July 2020 and upheld the rights of the Travancore royal family as well as the authority of the chief tantri on religious matters in relation to the temple. My involvement in the case required me to understand, among other things, the nature of Hindu princely states prior to their integration with the Indian Union, the relationship between heads of Hindu princely states and their titular deities, the circumstances, terms, and conditions of integration of Hindu princely states with the Union, the history surrounding the 26th Amendment to the Constitution, and of course, the recurring issues of the state control of temples. So, little did I know then that the experience of working on such matters of constitutional and civilizational significance would prepare me better to make sense of what was to transpire between August and December 2019. During this momentous period, Bharat witnessed the following. Amendments were undertaken to Article 367 and 370 of the Constitution on 5th and 6th August 2019, and the erstwhile state of Jammu and Kashmir was reorganized into two union territories with effect from 31st October 2019. A constitutional bench of the Supreme Court, led by the then Chief Justice of India, Sri Ranjan Gogoi, pronounced an unanimous verdict on 9th November 2019, affirming the ownership of the deity Sri Ram Lala over his birthplace in Ayodhya, thereby validating a 500-year-old Indic civilizational and religious movement to reclaim Sri Ram Janmabhoomi. The Citizenship Amendment Act 2019 was promulgated on 12 December 2019, which provided an accelerated access to citizenship for persecuted Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians from Muslim majority countries such as Pakistan, Bangladesh, and Afghanistan. Each of these developments generated significant debate, which was natural given that these were tectonic shifts in Indian history that touched upon quite a few fault lines and unresolved legacy and civilizational issues. That said, the most troubling aspect of these debates, which kept rearing its head over and over again, was that the very legitimacy and the underlying identity of the Indian state and the Indic society was called into question. We were being told that Bharat was a synthetic product of colonization which had no identity and a consciousness of its own before the European colonizer set foot on its soil and stitched it together that as one nation. Arguments that were allegedly rooted in the constitution were being marshaled to support these positions, which effectively turned the constitution into a battleground of sorts. The extent of the divide was such that I was told on social media that the use of Bharat for India was bigoted and against the constitution's promise of secularism. The fact that Article 1 of the Constitution expressly spoke of India, that is Bharat, to declare its root and heritage to the world was barely known. And even if it was known, the significance of the use of Bharat in its very first article of the document appear to have been lost over time. This is when I decided to examine the fundamental question to the relationship between India and Bharat through the prism of civilization and the constitution, and what it meant, if anything, to the state and to society at large. To this end, I began to write a few pieces for First Post and Open, capturing my views. In particular, I argued against approaching the constitution with a sense of affected and exaggerated religiosity without understanding it in the broader context of the civilization which I contended was the primary canvas as well as the object of protection. To romanticize and venerate the constitution, I argued, was to conflate the means with the end to detriment of the civilization. In a nutshell, I took the position that the constitution must be alive to history to serve its intended purpose. These were my tentative beginnings, and this intersection, and my thoughts took better shape when I spoke at a conference in Chennai on the Hindu character of the princely states based on the research that was put together for the Sri Padmanabh Swami temple case. Around this time, ideas for the book had started taking shape in my mind, and quite a few well wishers had begun to ask me to pen my thoughts in the form of a book. However, I first wanted to run my ideas through a series of pieces before capturing them coherently in the form of a book. This I felt would also help me to assess if I could balance my professional commitments as an arguing counsel with my writing initiatives, which I was still mulling over the prospect of writing a book. The world was hit by COVID-19 pandemic. I decided to use the respite provided by the lockdown to read up more on civilization and constitutional aspects before starting a column. I set out to try and make sense of existing ideological divides across the political spectrum in Bharat. It seemed to me that regardless of labels, that was common acceptance of the colonized version of Bharat's history, especially in matters of human rights, religion, education, environment, development, caste, and gender. In fact, there seemed to be a shared view across ideologies that there was indeed a universal and uniform moral standard that all civilized society must adhere to. Bearing a handful of scholars such as Ram Sarup, Sitaram Goyal, Dharmpal, Conrad Els, Dr. S.N. Bal Gangadhar, and Dr. Jacob D. Ruwer, very few seemed interested in challenging the Western normative framework which informed these so called universal standards. Even those who publicly extolled the Indic civilization for its spiritual, philosophical, legal, and epistemological traditions seemed more interested in calling out the selective application of such supposedly universal standards. For some reason, they would not question the application of the Western normative framework that refused to accommodate Indic thought. Critically, the ontological and the theological origins of this framework and their effect on non Western civilizations such as Bharat did not seem to get the scrutiny and examination they warranted. What piqued my attention was that the reservoir of colonial stereotypes about the Indic civilization, which seemingly opposing sides dipped into and drew from liberally, pun intended, was the same. While one reinforced the stereotypes to make the case that there existed no connection whatsoever between Bharat and India, the other highlighted the very same stereotypes to make its case for a liberal Bharat, a new idea of India, if you will, citing Bharat's innate openness to new ideas and reform. The former, at least, wore its antipathy to the Indic consciousness openly to its sleeve. The message that was being evangelized by the latter was a repackaged version of the Reformation, in this case, an Indic Reformation. Of course, the latter school of thought pursued its reformist agenda while paying lip service to Bharat and its civilizational character to placate the larger Indic society with tokenism. This was a critical layer in the national discourse which needed to be unpacked, in my opinion, since the larger goals of reclaiming Indic civilizational consciousness and agency over it were being relegated to the margins by both sides, albeit for different reasons. The result was the same. Bharat would continue to operate within the colonizer's framework while its civilizational character would be put to symbolic and ornamental use without any real and lasting impact on policy making. To me, this did not bode well even for Bharat's economic aspirations, since the premise of an Indic Renaissance, that is, a re-inscription of indigenous consciousness onto contemporary Bharat, was that it was not necessary for Bharat to play by the West's rule in order to achieve economic prosperity. On the contrary, I believed that a civilizational reclamation had the potential to spur confidence and originality of thought, thereby paving the way for economic progress in a way that was consistent with Indic ethos, which valued a balanced approach to nature and development. Critically, the pursuit of economic prosperity through the mere imitation of a Western framework, according to me, would cement the notion that the only viable way was the Western way, which would have irreversible and catastrophic consequences for the survival of Bharat's indigeneity. I believe that it would be unwise to put economics and civilizational priorities in walled gardens, because the relationship between the two was too close to risk a silo based approach. After all, the average person was bound to assume and attribute the West's economic prosperity to the values and ideas it subscribed to, and ultimately to its onto epistemology and theology. Also, I asked myself, was it not the ultimate goal to ensure that Indic thought had a respectable seat, its rightful position at the table of big powers? Unless, of course, the true objective was to preserve the hallowed status quo between the seemingly opposing camps, the sacred middle ground where all civilizational inquiry ended regardless of the side of the so called ideological divide one was on. This was when I started considering the possibility that maybe I was unaware of the existence of an unwritten code that allowed the envelope on the civilizational front to be pushed only so far and no further, thereby maintaining the hegemony of the Western normative framework in Indian discourse. What else could explain the unquestioned difference with which the framework was being treated by even those who claimed to stand for a living civilization that placed a premium on self confidence, critical inquiry, and truth? These questions led me to the view that it was important for the people to understand that Bharat as a civilization was a reality, and reducing that reality and a near unbroken lived experience to a mere talking point to score brownie points over the another was more a proof of expediency than real conviction in the values the Indic civilization stood for. After all, if one did not believe in the capacity of this civilization to offer a credible and viable alternative to the Western normative framework, at least for Bharat, it would be unrealistic to expect the rest of the world to look up to the Bharat as Vishwaguru, literary teacher or guide to the world. I believed that people that lacked the courage and the courage of their conviction to live by their own civilizational values could hardly expect the world to look up to them for guidance. Also, based on the writings of Leonine civilizational icons such as Swami Vivekananda and Sri Aurobindo, I believed every culture had something of value to contribute to the global pool of thought. It was therefore clear to me that recasting Bharat in the mold of West would kill its originality and character, making it a mere vessel of the West that too after the European colonizer had left its shores. That would be a tragedy of incalculable proportion, for which we would have none to blame but ourselves. To bring out the unconsciousness and unshakable belief in the Western normative framework across the political and ideological spectrum, I began my search for similarly placed movements in other societies, which could be compared with the Indic quest for cultural decolonization. While I was aware of the scholarly work of Dr. Balgangadhar and Dr. D. Rover on colonial consciousness in relation to Bharat, I had two reasons for undertaking the search. First, to demonstrate the global presence of such consciousness owing to the scale of European colonialism and its successor Western imperialism. And second, because contemporary Bharat unfortunately sought global validation of its position even on cultural decolonization. Therefore, to make a case for Bharat, I wanted to place its experience within or alongside a global framework in the hope that it would drive home the point better. Also, as a practicing lawyer, I sought a framework that would make it possible for me to strike a balance between civilizational imperatives and constitutionalism, especially in view of the ongoing debates surrounding the Constitution. One of the ways could have been to approach the subject through the prism of the historical school of jurisprudence based on the works of Frederick Karl von Savigny, George Frederick Puchta, and Henry Mene. However, I was interested in a non Eurocentric framework that was applicable to societies that shared Bharat's colonial experience and transgenerational trauma. My most critical expectation was the framework must be malleable and conductive to the Indic worldview, given that the Bharat's colonial experience had aspects that were both similar and dissimilar to the experience of other hitherto colonial societies. Therefore, my objectives were to continuously apply such framework to my own personal journey in understanding the Indic civilization or on its own terms and using its own lexicon, wants and all, and to extend the application of this framework in a concrete manner to my area of competence, namely the law, and more specifically to the constitution, given its manifest importance to the polity of Bharat. However, my search for a framework that was not helped by the fact that I lacked formal training in the area of humanities. I was at this juncture that in April 2020, I was approached to speak on the Indian Constitution at a webinar meant for Indian Americans. After the webinar, Dr. Indu Vishwanathan, a Hindu American scholar and educator whose brainchild the session was, happened to remark that my work on reconciling the Constitution with Indic civilizational perspective fell within the purview of decoloniality. To put it in her words, she called it decoloniality in action, which several other similarly placed societies had witnessed. She urged me to look into decoloniality in order to understand the applicability to the Indic civilization and was kind enough to share some of the literature on the subject. As a result, I started reading the works of scholars such as Annibal Cujano, Walter D. Mignolo, Sylvia Winter, Ramon Grossfigel, Catherine E. Walsh, and Nelson Maldonado Toros, among others. Dr. Vishwanathan also put me in touch with another brilliant scholar of decoloniality, Miss Sumita Ambasta, who introduced me to literature that shed light on colonial language policies and the writings to Arturo Escobar, whose perspectives on the relationship between coloniality and development is a must read for development professionals in Bharat. In my exploration of the subject, I learned that coloniality, as first conceptualized by Latin American scholar Annibal Cusano, informed the European colonizers' use of power and was the very basis and justification for the exploitation of the world. Coloniality was the fount of European colonialism, which in turn was rooted in the colonizers' religious beliefs that gave birth to the sense of racial superiority that placed the Christians, white European colonizer at the top of the world order. It was this sense of superiority which the European colonizer treated as both a divinely ordained right and scientific fact that led to the creation of racial hierarchies the world over. Coloniality reshaped the very concept of history and time through the creation of constructs as modernity and rationality, terms which are loosely used in contemporary contemporary everyday conversation without the knowledge of their colonial origins. This colonial matrix of power, to which both modernity and rationality were integral, had the effect to negating the cultural experience and subjectivities of colonial societies, so much so that according to colonizer their history began only upon his advent. The literature taught me that decoloniality was the response to coloniality and the Eurocentric Western normative framework introduced in colonized societies by the European colonizers. The goal of decoloniality was to unshackle hitherto colonized societies was the totalizing universalism of European colonialism and its current day successor, Western imperialism, and in order to restore agency and dignity to their consciousness. The more I read the literature on coloniality, the more I realized that there was a clear and inadvertent handshake between such literature and works of Dr. Bal Gangadhar and Dr. D. Ruver on colonial consciousness. This told me that at the very least, the framework merited serious consideration, whether or not it held all the answer to the consciousness related question faced by the contemporary Bharat. Also, the framework gave me the opportunity to call out the double standards that were being applied to decolonial movements in other decolonized societies on the one hand, and the Indic movement for cultural decolonization and reclamation of its civilizational identity on the other. While the former had received serious and positive attention, the latter had been branded illiberal, xenophobic, and lacking in historical basis. This hypocrisy needed to be called out. By the first week of May 2020, I began writing a Friday column, Indic Views in the Daily Guardian, on the interplay between civilization and the constitution, approached through the lens of decoloniality. The column received a positive feedback for its take on a new approach to constitutionalism. By early September 2020, after writing close to 18 pieces under the column, I knew I was ready to write a book on the convergence between coloniality, civilization, and the constitution, by no stretch of the imagination as an expert, but as a genuine and committed learner. The hope was that it would start fresh, timely, and nuanced conversation in and about Bharat on these issues, and so the second week of October 2020, I started writing the book. This book. This book is the first part of the Bharat trilogy that explores the influence of European colonial consciousness, coloniality, in particular its religious and racial roots, on Bharat as a successor state to Indic civilization and origins of the Indian constitution. It lays the foundation for its sequels by covering the periods between the age of discovery marked by the Christopher Columbus expedition in 1492. So, age of discovery by Christopher Columbus expedition in 1492, and the reshaping of Bharat through a British made constitution, the Government of India Act 1919. The book is split into three sections: coloniality, civilization, and constitution, with the third section as the ultimate object of my attention. The canvas is global in the first section and moves towards Bharat-centric analysis of coloniality, colonial consciousness in the second, and third with greater specificity. Given the abundance of standalone literature on the subjects of the first two sections, I have limited the scope of the discussion only to the extent it serves as the foundation for my examination of the Constitution for coloniality, colonial consciousness in the third section of this book and its sequels. In the first section, citing the literature on coloniality, I broadly discuss the genesis of a Eurocentric Western normative framework starting from the age of discovery, which begin with Christopher Columbus expedition in 1492, its religious inspiration and racial underpinning, its relationship with modernity, rationality, its impact on colonized societies, and the rise of decoloniality as a response. In particular, I have focused on the impact of coloniality on nature, religion, language, knowledge, education, and law, and the Westphalian origin of a nation state. I have also taken the position that, owing to its Latin American origins, decolonial scholarship focuses primarily on European coloniality, and therefore its vision of decoloniality is limited to the same. This means that every society should identify the forms of colonization it has been subjected to and the outline for itself the contours of its decoloniality. In the second section of the book, in the backdrop of the global experience with European coloniality, I have discussed its impact on Bharat primarily in the realms of religion, caste, tribe, education, and political infrastructure, covering the period between 1600 and 1853. This section also traces the origin of seemingly universal constructs such as toleration, secularism, and humanism to Christian political theology. Their subsequent role in subverting the indigenous Indic consciousness through a secularized and universalized reformation is examined. I have also put forth the concept of the Middle Eastern coloniality since Middle Eastern colonization of Bharat preceded the European variant, the underlying idea being that Bharat's version of decoloniality must address both forms of colonialities to preserve its civilizational character in the light of its history and continuing contemporary challenges. Further, I have explained why post-colonialism in Bharat has served to entrench both arms forms of colonialities and must therefore give way to decoloniality. The third section is effectively an extension of the second, but with a greater focus on Bharat's colonial constitutional journey. This section covers the period between 1858, when the British Crown directly took the charge of Bharat, and 1919, when the first British made constitution for India, that is, the Government of India Act 1919, was passed. This includes international development leading to the founding of the League of Nations by the Western powers that tangibly impacted this journey. The object of this section is to demonstrate that the civilizing and evangelizing tendency of the European colonizer, which emanates from his coloniality, impacted the political legal infrastructure established by him in Bharat, including a constitutional form of government. The other important object is to underscore the use of international law by European colonizing nation to universalize their evangelical mission. The discussion in this section of the book serves as the foundation for the sequels. The first sequel, which will cover the crucial period between 1920 and 1951, when the Constitution of Independent Bharat was framed and adopted and amended for the first time in 1951. The second sequel will tentatively cover the period between 1952 and 1977. I must caveat this endeavor by stating clearly that by no means in this analysis of the Constitution comprehensive. However, it is certainly intended to be a starting point from a decolonial perspective so that Indic consciousness can replace colonial consciousness. The attempt has been to share my learnings in the hope that they trigger a much needed round of fresh and honest conversation, not just among the specialists, but even and especially among non specialists who seek to make sense of all the noise being made around the identity of Bharat and its constitution. In the process, I have tried my best to let facts speak for themselves and have attempted to draw only those interferences and conclusions that are reasonably supported by literature. Whether or not I have succeeded in this exercise is, of course, for the readers and posterity to judge, applying a decolonial lens. As for the tautness and the rigidity that have crept into my writings over the years, that are occupational hazards of being a litigator. On the overall quality of this of the exercise, I leave it to the readers to decide if the book reflects my commitment to my journey as a learner. So this was about the introduction of this book of massive 20 pages that I have covered uh, without stopping in between. So we'll try to cover the the complete book uh, chapter by chapter. So till then, we'll meet again for the first chapter, that is the colonization, colonialism, coloniality, and decoloniality language matter. So I would try to cover 15 pages, 15 pages in every video, because if the pages will be more than 15, then the length of the video will be greater and my throat will also start paining. So that's why I will start covering 15 pages every day. If a certain chapter will contain 2 or 3 extra pages, then I will try to cover more than 15 pages, but around 15 pages I would like to try to cover, and try to finish this book within the specified time limit. Till then, thank you.